appeal court is complaining about some trial judges' blizzard of words in factual data dump. Although this is not technically a family law decision we're looking at, a recent Court of Appeal ruling in Welton versus United Lands Corporation Ltd. offers some advice to any judge who must rule on and write decisions in any area of family law. In particular, the court cautions against judges using a blizzard of words or a factual data dump in their rulings. These can not only serve to obscure, but often they result in the type of verbose judgment that lawyers, the parties, and any subsequent appeal judges must take extra time to read and digest. The facts in Welton amounted to what was essentially a straightforward contract dispute. In the course of the hearing and ultimately dismissing the appeal, the Ontario Court of Appeal reviewed in detail the exhaustive 550 paragraph decision of the trial judge. After doing so, the court offered some important guidance to all fellow judges, regardless of the area of law, in connection with the task of writing judgments. The Court of Appeal said that they conclude by expressing a concern about the length of the reasons for a decision in that particular case, which is reflective of an unfortunately growing trend, of which this is not the worst example, but it is one before the court at that time. Trial judges attend to the evidence in light of the relevant law, listen to it, and think about it. Draw the appropriate inferences, distill the key evidence, make factual findings, apply the law to the findings, and communicate the basis for the decision to the parties through the reasons. Of these various tasks, simply being present to receive the evidence is only the trial judge's first step on the path to a decision. After explaining the desired structure to be used by judges in the initial course of their decisions, which is to first identify the legal issues and then recite the facts, the Court of Appeal continued. It is important for trial judges to focus the analysis on the live issues that will decide the case. There is, to emphasize, no need to recite all of the evidence, even the irrelevant, or to refer to every argument made by every party, no matter how unhelpful. Appellate court sees reasons for decision that do not address the evidence and the arguments and are criticized as conclusory on the one hand, and decisions that leave nothing out on the other hand. The task of the trial judge is to find the golden mean to decant and simplify, to synthesize the evidence and make necessary findings. The task is not to be a court reporter. The Court of Appeal then homed in on what it considered to be one of the fundamental problems with such overlong rulings, and used the present judge's decision, now under appeal, as an illustration. Many overlong decisions, including this one, contain what the court called a factual data dump. Pages 5 to 7-9 consist of witness-by-witness account of examination in chief, cross-examination, and re-examination. The analysis of this evidence starts at paragraph 394 on page 79 and repeats some of the evidence previously reviewed, adding to the length. Perhaps this emerging style is the artifact of electronic note-taking by judges, but it's not helpful and can be confusing. A blizzard of words can be obscure. Digesting unduly lengthy reasons consumes far too much time, because every word must be read by the parties, by their counsel at great expense, and by appellate courts. A data dump does not constitute fact-finding. It is extended note to self, best kept to oneself, because it hinders the efficient and economical communication of judicial reasoning. Do you agree with the Court of Appeal that for trial decisions, less can be more? Thank you for watching today. Like and subscribe to our videos. Make your comments. We'll try to answer them at the end of each week. Until next time, I'm Russell Alexander.